This video mini-series is intended to help clarify for Canadians some of the key issues swirling around the so-called Lavscam scandal. A separate video looks at the issue of the Prime Minister's claim that he was motivated throughout this dispute by a desire to protect jobs, notably the 9,000 jobs engineering giant SNC-Lavalin has in Canada. This video focuses instead on the prosecutorial independence at the heart of the dispute, which saw former Justice Minister Jody Wilson-Raybould and her colleague Jane Philpott resign from cabinet over allegations of improper political interference by the Prime Minister's office and the Privy Council Office in a prosecutorial decision. Understanding the principle of prosecutorial independence requires us to think for a moment about what it means to be a society under the rule of law. To understand the rule of law, it is perhaps easiest to contrast it with places where that rule of law does not exist. Take China or Russia, for instance, where the machinery of the state is under the unfettered control of political authorities and can be used by those authorities to punish their enemies and reward their friends. People who incur the displeasure of political authorities can find their property seized, they can be arbitrarily imprisoned, prosecuted on trumped-up charges, and even assassinated. Their families may be terrorized by the police. Under the rule of law, recognizing the danger the state can pose to our life, our security, and our peace of mind, we subject the power of the state to various kinds of controls. Those controls aim to ensure that when the state uses its coercive power against us, it does so to enforce the law, and only the law, as adopted by democratic processes. As a shield against mistakes, and to keep political cabinet ministers and others from thinking the state exists for them to use at their pleasure, we have three separate decision-making bodies that determine if there is a case the law has been broken, and then to decide if that case is proven. Those bodies are the police, the prosecution, and the judiciary. It is a fundamental principle of the rule of law that each of these three agencies must be left free of political interference in their work. The better known of these three are the police and the courts. We do not live in a society where cabinet ministers can call the head of the RCMP and say, "Joe Dokes is a pain in the neck. Let's teach him a lesson. Arrest him and throw away the key for a few months." The RCMP and other police forces in Canada must be given the freedom to investigate crimes independently of political influence, limited only by the powers they possess under the law. It's the same with judges. Once a matter is before the courts, not only would it be scandalous for a politician to phone the judge and try to influence his or her decision, but public authorities are very careful not even to comment on matters before a judge, lest that be seen to be an attempt to signal to judges what a desirable outcome would be from a political point of view. When a citizen's property, rights, and liberty are in jeopardy, nothing less than this rigorous shielding of judicial independence is acceptable. An independent prosecutorial service is just as important as the other two. Prosecutors examine the evidence in a case and determine, without political interference, whether it justifies a prosecution before a court and, if so, what the charges will be. And as was the case with the police and the courts, prosecutors are expected to be guided by the law, not the political preferences of governments. No politician is allowed to press for a prosecution in an individual case, or indeed for a prosecution to be dropped when powerful and influential people come under the scrutiny of the justice system. This is precisely what it means to be under the rule of law. Public authorities may not act arbitrarily or in pursuit of any objective but applying the law without fear or favor. This is the nub of the dispute between Prime Minister Justin Trudeau and former Justice Minister Jody Wilson-Raybould. SNC-Lavalin was the subject of a police investigation that found sufficient evidence to justify criminal charges of corrupt behavior. The Director of Public Prosecutions had a choice. either to bring the criminal charges before a judge or to negotiate a so-called deferred prosecution agreement with the company in which it would admit wrongdoing and pay restitution, but would escape criminal prosecution. DPAs are not available to all offenders, however. There are conditions that must be fulfilled. The Director of Public Prosecutions determined that, under the law, a criminal prosecution was the correct route to follow, presumably in part because she felt the company did not meet the legal conditions to get a deferred prosecution agreement, and she notified the company of this decision. The Justice Minister, Jody Wilson-Raybould, reviewed that decision and satisfied herself that it was correct under the law and that she would not issue an order, which she had the power to do, to pursue a DPA instead. The company, dissatisfied, launched a court case to try and get a judge to force the prosecution to pursue a DPA. So, we had an independent prosecutorial decision to forego a DPA and pursue criminal charges, and we had a case before the courts on these very issues. In other words, 2 reasons for politicians to give this matter a wide berth under the rule of law. It was in this context that Jody Wilson-Raybould says she was subject to improper political pressure from a variety of sources around the Prime Minister, including Justin Trudeau himself, to change the independent prosecutorial decision. Trudeau and his advisors say they were only giving context, which they are entitled to do. But as Wilson-Raybould testified before the Commons Justice Committee, these interventions went far beyond context and included both improper political factors, such as alleged job losses at SNC and the impact of an adverse court decision on the government's re-election prospects, and alleged veiled threats that her job as minister was at stake if she didn't play ball. Clearly, the entire story has not been told, not least because the Prime Minister will not give Jody Wilson-Raybould a waiver from her oath of cabinet secrecy to do so. Until such time as we possess more facts, it would certainly appear that there is a case for the Prime Minister to answer about whether he acted improperly and in violation of the principle of prosecutorial independence. If he did so, his claim that he was only acting to defend Canadian jobs is actually no defense at all. The principle of independence at stake is designed to ensure that such political factors do not impinge on the integrity of the rule of law. I'm Brian Lee Crowley for the Macdonald-Laurier Institute.